Hello, friends. I welcome you all to this session of Indian Evidence Act. And today we will be seeing Section 137 and Section 138, which are basically definition and order clauses. So, what Section 137 does is that it gives definition of three terms: examination in chief, cross examination, and re examination. Let us see one by one. So, examination in chief. So, examination in chief means the examination of the witness by the party who calls him. So, suppose there is a case between prosecution and defense, and prosecution calls a witness, say W1, W. Now, if the prosecution has called the witness, then examination which will be done by prosecution will be called examination in chief. Then cross examination, the examination of witness by adverse party is called cross examination. So in this case, D or defense is the adverse party. Now the examination which will be done by D or defense of W, that will be called cross examination. Then re-examination, examination of a witness subsequent to cross-examination by the party who called him shall be called re-examination. So once cross-examination has been done, then again if W is being examined by P, the party who called him, then that will be called re-examination. So examination in chief means examination of the witness by the party who called him. Cross examination means the examination by the adverse party. And the re examination means examination subsequent to cross examination by the party who called him. Next is chapter 138, which provides the order or the sequence in which this examination in chief, cross examination, and re examination is to be done. So, as you can see here, first of all, there will be examination in chief, that will be followed by cross examination, that may be followed by re examination if necessary. So, this will be the chain as such. So 138 provides that witness shall be first examined in chief, then if the adverse party so desires, cross examined, then if the party calling him so desires, re examined. The examination and cross examination must relate to relevant fact, but cross examination need not be confined to the facts to which witness testified in examination in chief. So examination in chief and re-examination. This too should be confined to the fact in issue or relevant fact. But cross-examination need not be confined to only those matters within which the examination of chief or re-examination has happened. It may even relate to the veracity of the witnesses as such. Now, direction of re-examination. What it says is that the re-examination shall be directed to the examination of the matters referred to in cross-examination, and if new matters are by permission of court introduced in re-examination, the adverse party may cross-examine upon that matters. So suppose if W is first examined in chief, thereafter on these points which on which examination in chief took place, and on some other point he may be cross examined, and if new matters come up, then he may again be re examined by the party who calls him, And in this re examination, if some new fact has come up, suppose this is the new fact which was not there earlier in examination in chief or in cross examination, then on these facts, once again, the adverse party will be allowed to cross examine him. Now, cross examination can extend to all relevant facts, whether raised in examination in chief or not. So, what it says simply is that cross examination need not be limited to the facts in which examination in chief to which examination in chief has taken place. It may extend to some other facts also. Now, in Sukhwant Singh versus State of Punjab, it was held that witness cannot be thrown open to cross examination unless he is first examined in chief, where the prosecution did not examine a witness and offered him to be cross examined. It was held that this amounted to abandoning of one's own witness. Such an approach can seriously affect the credibility of prosecution case. So, what in this Sukhwant Singh versus State of Punjab it was held is that suppose a witness comes in the court. Now, first of all, he has to be examined in chief, and then only his cross examination is to be done. It cannot be allowed that the prosecution says that I don't want to cross examine him, I don't want to examine him in chief. You start with cross examination. That will not take place, or that is not to be permitted. In case the prosecution doesn't examines his own witness or does not carries out examination in chief, then that witness as such his cross examination cannot be allowed, and the statement of the witnesses will not be taken in that case. Now, another point which is very important is that a co-defendant can be cross-examined by another co-defendant if their interests are adverse to each other. So, suppose there is a plaintiff and there are two co-defendants, then these two can cross-examine each other if their interests are adverse, though they are both are defendant in the case. Now, if re-examination introduces new matter, the other party will get right to cross-examine the witness over the new matter. So suppose a witness W is there, he is examined in chief on these points, then his cross-examination took place on these points and on some other points also. Thereafter, he is re examined, and in this re examination, some new points come up. Then, for these new points, he can again be cross examined by the adverse party. So, that is all with section 137 and 138, where in 137 we saw definition of examination in chief, cross examination, and re examination. Examination in chief is examination by the party who called. Cross examination is examination by the adverse party. Re examination is examination subsequent to cross examination by the party who calls the witness. Then, section 138 provides the sequence which says that first of all, examination in chief will take place, then cross examination, that will be followed by re examination. And if new matters come up within re examination, then again the party can be cross examined. That's all for today. Thank you, friends.